Great. All right. So we wanted to let folks know that we will be recording today's meeting because not everybody can participate, and some folks wanted an opportunity to review this material at another time. When we get to the question and answer, I think we're going to cut the recording there just to make it a more reasonable length of time to review. And then we'll be answering questions through the chat feature, just because there's so many folks in this meeting today. Although we may call on some of the folks who are participating to help us respond if we need to, and at which point you can certainly unmute yourself. So, with all of that said, let me thank you again for coming and introduce myself. I know most of you, but not all of you. I'm Valerie Richardson. I'm the Title IX coordinator for the University of Washington. And of course, our office serves all campuses and locations of the university. And we really appreciate so much collaboration that we have across all these locations. Mags, if maybe you could unmute yourself and just do a quick introduction as well.
Yes. Hi, everyone, and thank you for coming. I am Megs Alex. I'm the Deputy Title IX Coordinator at UW.
Great. All right. So the first thing that we just want to touch on, and some of you have heard us talk through some of these commitments before, but I want to remind all of us here today, and for those of you who haven't seen it, that regardless of what laws or regulations we're addressing or responding to, the University of Washington is remaining committed to providing respectful learning and working environments. We're remaining committed to preventing and responding to discrimination, harassment, and violence regardless of where it occurs. We're committed to showing leadership in achieving gender equity, and with starting with compliance is the floor. We have to comply with the law, but we can do more and we can build up from there, and we're committed to doing that. We are going to continue in this space and any space we find ourselves to address all forms of sexual misconduct. We're going to continue to offer and prioritize support measures and options to survivors. We're going to continue to provide due process and support resources to respondents. We will continue to prioritize equity and fairness. And of course, we're going to proceed with developing our prevention and awareness initiatives. So I mention these things because so many folks have been very concerned about these new rules and the chilling effect that they likely may have on reporting. We want to continue doing the work that we're doing and make our processes as accessible as they can, as well as address misconduct and unwelcome behaviors in all ways that we can do so. Before we get into the kind of the weeds of what the federal Title IX regulations require, we wanted to make a mention of some other laws that also inform and impact our work. Certainly Title IX is important. It's what our office is named after, but we also are responsible for addressing and incorporating plenty of other laws and sort of guidelines. And so Mag's going to take a minute to talk through some of those.
All right. Thanks, Valerie. So I'm sure you all are aware of this, but Title IX, of course, is the federal gender equity law that covers educational institutions. It protects individuals' access to academic and workplace environments and requires that these spaces are free of sex discrimination and sexual harassment. In addition to the federal Title IX law and its implementing regulations, the University of Washington must also comply with a variety of other laws. And these include Title VII, which is part of the Civil Rights Act of 1964. Title VII prohibits employment discrimination based on a variety of protected classes, such as race, color, religion, sex, including pregnancy status and national origin. And then finally, as of June, the Supreme Court has clarified that the sex also includes sexual orientation and gender identity and expression. Title VII also requires employers to address behaviors and take prompt and appropriate corrective action upon learning of discrimination or harassment based on any of these protected classes. In some cases, this could require a more expedient process than contemplated by the new federal Title IX regulations. The Violence Against Women Act, or VAWA, required amendments to the Clery Act, and those two laws also impact our work. VAWA defines crimes such as sexual assault, stalking, domestic violence, dating violence, and the Clery Act establishes how universities must track and publish data about crimes on campus. Collectively, these two laws also create requirements for policies, procedures, training, and education and prevention work. The Washington Law Against Discrimination is another law that impacts our work. It applies to employment and other areas of public accommodation in Washington. The law also makes it illegal to discriminate on the basis of many of the same protected statuses as Title VII and includes several more. House Bill 2327 is a new Washington bill that was passed this past year, and it also impacts our work. This bill has a schedule for implementing various provisions, and UW is complying with this law as well. House Bill 2327 requires that the University of Washington complete investigations of its employees, keep records of substantiated findings, provide those when other employers request and require that the University of Washington conduct reference checks. The law also bans non-disclosure agreements and requires that all new employees attest that they have not been investigated for sexual misconduct by prior employers. Further, other laws that have little to do with gender equity or sexual misconduct may also impact how the University of Washington complies with Title IX and these other laws. For example, because the university is a public institution, we must also comply with the Washington Administrative Procedure Act, and that has impacts on things like the Student Conduct Code and student conduct process. So in implementing Title IX, we are cognizant of the differences between equality and equity. If you view these two images, you'll see that equality, where each individual gets one box, does not result in everyone being able to watch the baseball game. And of course, when none of us is able to watch baseball games, thanks to COVID these days, the only way to watch is over the fence. So we want to make sure everybody can see. Older versions of this graphic included even ground and a fence that was all of the same height. The element that was different was the height of individuals. Here, the fence and the hill are sloped in such a way that they impact people differently. It's not the people who are different, but their relative standing in society is not equal because of systemic inequality and oppression, which permeate our culture and our society. In the context of Title IX, the boxes represent different supports and services and policies. Based on individual characteristics, people need different things to be able to access their academic or employment environment, and we will strive to do that. I'll also note that if we want to strive for justice, our ideal would be the destruction of the fence altogether, but these past several months have shown us just how ingrained and strong systemic inequality and oppression is. I'll turn it back over to Valerie to talk about UW's compliance.
Okay, before I get into the phased approach that we're following, I do want to take a minute to acknowledge all of the work that has gone into getting us to today and where we expect to be on Friday. People from around the university have been part of this enormous lift. I think folks know that we were given about 100 days and about 2,000 pages with some pretty hefty surprises that didn't comport with the proposed regs. And we had folks from student life and student affairs across all of our campuses, human resources, academic personnel, the policy and rules office, the attorney general's office, our executive office, of course, our UCERO and Title IX investigators, our hearing officer, et cetera, folks from every corner of compliance services, rolled up their sleeves to help us get to the place where we're at now. And we will acknowledge, I think from the beginning, we knew that even with all this incredible intelligence and expertise, having just 100 days to get this done by August 14th wasn't going to put us in a place where we all felt like we had done a really thorough, engaged process that got us to the very best solution in every case. And so with that said, phase one, which is getting us to the August 14th implementation date, includes some interim and kind of emergency approaches, right? So interim executive order 70 will be published on Friday. And that basically addresses a majority of the content that is required by the federal rules, with a special emphasis on the grievance procedures that will be utilized for employees when the federal rules apply. We're also publishing the Washington Administrative Code, the WAC emergency rules that specifically focus primarily on the grievance procedures for students. And then, of course, we've been spending time developing processes and procedures in and around and outside those two documents that blend in or complement or are parallel to other UW policies. And we've also, of course, been working on our communication and training strategies. So those things are what we've been focusing on in phase one. And given the broad range of folks who are here today, we have investigators, we have trainers, we have students who all touch this work in different ways. What we'd like to do is give you an overview. In some cases, we're going to dive a little bit deeper, but then ask you when we're done, if there are things you really felt like we needed to get into in more depth, let us know that, and we can talk with you or set up, additional sessions or time to talk with specific groups as needed. So that's kind of my sort of caveat in terms of what got us to phase one. In phase two, we're going to be, of course, monitoring any court rulings or political changes that might impact our need to fully implement the rules. We'll be assessing and evaluating and adjusting our phase one solutions through work teams and outreach to other colleges and universities and working with all of you. And then, of course, if nothing changes and we need to proceed this course, we'll have to finalize our emergency rules, finalize the Washington Administrative Code, and incorporate the various elements in sort of interim Executive Order 70 into policy in a more permanent way. And we'll need to find some ways to do that that's a little bit more seamless than what we've done now. So I also want to share a little bit about our communication strategy. In June, we held 2 community conversations and sent email messages to a variety of UW populations, letting folks know how we were proceeding and inviting engagement. It was a terrible time to proceed, not only because of COVID and all the things that were going on in the world, but because also it's summertime, right? So nevertheless, we needed to proceed. For August, where we are right now, we have put a lot of energy into updating the Title IX website, and either later today or tomorrow, I'll be sending out the new address for that. It's a slightly different address because of how it's positioned in kind of the hierarchy of the websites at UW. There are also 2 new pages in addition to a bunch of other content that's been updated. There's 2 brand new pages. One is an FAQ page and one is a for faculty and staff page. So invite you to look at those pages when I send those links out, and we welcome feedback. They'll continue to grow. We didn't get everything there that we want to have there, and we welcome your suggestions on what should be there. We've also updated the Know Your Rights and Resources Guide to be responsive to the federal rules. Got some really good partnership on that, and I feel like that's in good shape. Updated our STOP brochure, an internship brochure. Tomorrow, we'll be sending out notices to all of our admissions, human resources, academic personnel, graduate school, first-year programs, for example, with some notice information that is required to be posted and basically required by the rules to let folks know who the Title IX coordinator is, how to make a formal complaint. And this needs to go to not only every student and employee, but everybody who's applying to be a student or an employee. So that information will go out tomorrow. And then on Wednesday, we'll be sending an email message to every member of the UW community, all employees and all students, alerting folks to the fact that these rules go into effect on Friday, and offering some information and pointing them to a variety of resources and information sources. So that's our basic communication strategy. In the fall quarter, what we really want to focus on is doing more specific kind of group-based outreach to deans and chairs and administrators. We want to do communication with campus safety offices and UW PD. And then in October, we'll be scheduling additional community conversations, hopefully more email messaging to folks. And I really appreciated the partnership with the Vice President at Seattle, Dean at Bothell, the Vice Chancellor at Tacoma, in direct messaging to students last spring. It would be terrific if we could do that again. So those are some of our fall quarter communication strategies. If people feel like there's different strategies we should be considering and employing, I'm super open to hearing that input. We really appreciate ideas and things that have worked well for folks in other sort of settings. So what I'll do now is kind of give you an agenda for the rest of the meeting. And we've titled it Title IX in a Nutshell. And what we hope to cover, and we'll spend a couple minutes on each of these things. Like I said, invite you to let us know where you'd like us to dig in a little deeper in future sessions or meetings or conversations. But what the Title IX regulations require includes training of Title IX personnel, some very specific requirements there. It includes some different types of record keeping. It includes, it identifies a whole new category of employee, which in the rules is called officials with authority. And at UW, we have transitioned to calling it officials required to report, or Title IX officials required to report. The regulations require supportive measures, and it's kind of a broad-based requirement that's really different than previous guidance. And we'll talk about that a bit. It explains specifically what a formal complaint is and how it can be submitted. Again, very different from previous guidance. It defines the prohibited conduct. That's what I think people have heard the most about, is what really is considered prohibited conduct under these rules. It further clarifies, who can submit a complaint and what jurisdiction the university has when it comes to the federal rules. We'll talk about that a bit. And when the prohibited conduct meets the federal rule definitions and meets the criteria and jurisdiction, there's a very prescribed grievance process that needs to be utilized. And so we're going to touch on all of that today. One of the things I wanted to be sure to highlight that was a surprise to some of us is that these rules apply to all employees and all students. There had been some assumptions that since so much of Title IX in the past had been focused on student procedures, that might be the case this time around as well. The fact that the prohibited conduct and the grievance procedures also apply to employees as well as every other part of the regulations has really created an additional lift in terms of getting some processes and procedures in place to be in compliance with that. All right, we'll jump right into that agenda, and I'll start with training. Basically, the federal regulations require that all Title IX personnel, which include coordinators, investigators, and decision makers, get trained on specific things. And as you all know, or most of you know, at the University of Washington, we have a broad network of how we get Title IX work done. So kind of figuring out who needed to be trained and what they need to be trained on is an evolving process. But for now, we're looking at coordinators, investigators, and decision makers. And so they need to be trained, and they need to be trained on specific content. That content includes definitions of prohibited conduct, for example, what jurisdiction the university will be taking, how to do the job with impartiality, how to identify potential bias in yourself, how to conduct an investigation, how to assess evidence, etc. There's a variety of content areas. And then whenever that training is delivered, however it's delivered, whether it's through kind of in-house procedures or through maybe a TICSA or a Title IX specialist or other groups that we use, we need to post the content of that training publicly. We need to post it on our website. And so we're coming into implementation, or UW is implementing these requirements by starting to document all of the training that those individuals receive, both groups and as individual folks. We will be posting the content on our Title IX website. So when you get a chance to view our updated website, you can go to our Education and Prevention tab, and you'll see that there's a sub-page called Training for Title IX Personnel, and we'll have some language there that summarizes the kind of training that people generally get. And then as training starts to occur after August 14th, which is the requirement date, we'll be posting links to that content. And then, of course, we're doing our partner training today. This isn't a requirement of the new regs, but because there's so many changes, we thought it would be helpful. And at the end, if it is helpful, let us know, and we'll continue to do these kinds of things. We'll be seeking your feedback for sure. So. All right, the next thing that the regulations require that I'm going to talk about is record keeping. The federal rules require that we keep records related to all of these items: supportive measures, investigations, findings and sanctions, appeals, and training. And we must maintain these records for 7 years. Most of these records were already being maintained, many for a period of 5 years. So we're needing to make that adjustment as well. So in terms of how we're coming into implementation, we're basically updating our record schedule, and we're also looking at expanding the use of the advocate software that's currently being utilized on 2 of our campuses. We're going to be joining in with community standards and student conduct on the Seattle campus and expanding that as a means for keeping some of our records as well. So we are excited about that. Okay, let me transition to Title IX officials required to report. And the rules, for those of you who are familiar with them, this is the group of employees that's referred to as officials with authority. So the new regulations eliminated the responsible employee requirement. As some of you are aware, many colleges and universities around the country interpreted that previous language to mean that just about every employee needed to report whatever sexual misconduct or alleged sexual misconduct they may become aware of, and their Title IX office would need to investigate or otherwise address the behavior. At UW, we did not have that kind of responsible employee policy, but instead, we strongly encourage everyone at the university to initiate the Title IX protocol, in other words, call Safe Campus, when they were aware of sexual misconduct. And of course, there were some more specific expectations for some employees as well. We appointed a committee last spring in response to a work group report, which some of you are very well familiar with, so that we could get ourselves into a place where we had a policy that helped clarify for people so they would know what was expected of them, and that we did really what was best for the people who experienced the harm, the unwanted behavior, the sexual misconduct. That committee will continue, get back to its work, but we just wanted to kind of point out that that obligation to identify responsible employee is no longer present in these new rules. We certainly can continue to do that kind of work if we want to. But back to the officials required to report, or to the officials with authority. The new federal rules now specifically limit universities' obligation to take action when the university has actual knowledge of alleged or possible sexual misconduct. And then actual knowledge exists when a Title IX coordinator or an official with authority, an official required to report, is aware of possible sexual misconduct. The federal rules notably don't define who an official with authority is, so each school needed to define that for themselves. I'll note that in the K-12 environment, in case any of you have sort of connections there, every employee is considered an official with authority. But in the higher ed environment, we had some flexibility with that definition. So at the University of Washington, we've defined an official with authority we've defined it by using three possible buckets. A, anyone with a direct reporting line to the president or provost. B, those with the authority to impose a full range of disciplinary sanctions, if you will, up to and including termination from a job or dismissal from the university. And then three, those who are otherwise designated by the Vice President for Human Resources, by the Vice Provost of Academic Personnel, or by Compliance Services. Those folks have been identified and will be notified tomorrow with specific instructions on what they need to do, which really basically is going to be to initiate the Title IX protocol. They need to call Safe Campus. There'll be a few extra twists in terms of what those folks are required to do. And we can talk about that in a moment as well. But once an official with authority or an official required to report is aware of possible sexual misconduct, the university does have specific obligations. And those obligations are pretty straightforward. We need to offer and facilitate supportive measures. We need to explain how to make a formal complaint. And we need to document that we have taken those steps. Mags will go over that in more detail when we get to that in a minute. So with that stated, let me show a graphic that we have developed, and y'all can tell me afterwards or in the comments if you think this is helpful. But this is as we're trying to think about how to make these requirements work as best we could with our present UW systems, which we felt were working pretty darn well. Here's what we have come up with, all right? So this is our pathway to support measures and reporting options. The person in the top left corner of the screen is the person who has experienced harassment or other unwanted behavior or conduct or harm. As always, of course, that person can go directly to a confidential advocate. It's the best way to ensure confidentiality, and we will continue to prioritize that message in all of our communications. A confidential advocate, of course, will offer supportive measures, explain the option of making a formal complaint or going to the police if that's something that makes sense. But that's something that would happen in complete confidentiality if they go there directly, okay? The other thing that the person in the top left-hand corner can do is if they want to make a formal complaint and they're ready to do it, and they don't need more information, they can go directly to an investigation office right here, you know, at the bottom of the screen. And that would be the CIRO office or the Title IX investigation office. And so those are the two places, and those offices are co-located, like I think most of you know. If they show up there, whether it's through email, phone call, or in person, if we're ever there again, and they haven't already connected with an advocate, as is the practice now, they will be referred to an advocate if they're interested and willing, because we feel like that's just the best way to ensure that folks get support and really understand their options and what to expect moving forward. The other thing is that person can go straight to the Safe Campus or to the Office of the Title IX Coordinator. And that's something that can happen now and will continue as well. And if that happens, certainly working together, and we have a very collaborative system that's been in place for quite some time, we would be sure that that person gets referred to a confidential advocate, they get a Know Your Rights and Resources guide, and understand what options they have moving forward. And everything that they do with the confidential advocate thereafter, of course, is confidential. What's different on this chart from what we've done in the past is now we have officials with authority. We need to change that header to Title IX, officials required to report. And when they become aware of any potential misconduct, they must report it to Safe Campus and the Title IX coordinator. So Safe Campus is where we're directing people to. If people come to us directly, we'll make sure Safe Campus has that information and vice versa. That information is shared back and forth between the Office of the Title IX Coordinator and Safe Campus as it is now. And then of course, anyone within or beyond the UW community will continue to be encouraged to utilize Safe Campus as a resource for support, and they're able to continue to call anonymously. They're able to continue to share limited information when they call if they don't want to reveal someone's name who's experienced harassment or assault or other misconduct. So we've basically taken the requirements of the federal regulation and worked to fold them into our current processes that we believe are working well. And certainly this is an area that we will be focusing on and assessing to see if it really is working once we get started. The big difference here that I'll highlight is that if an official with authority refers to call Safe Campus and we refer that person to a confidential advocate, we do have to document that we have made an offer of supportive measures and explained the option to submit a formal complaint. So our advocates are working with us to make that most basic of documentation, and that's one of the areas we'll be looking at closely as we proceed. Okay, I think the last thing I'm going to talk about before I turn it over to Mags is the difference between a report and a complaint. You've probably heard me use that language already in today's session, and I want to be clear that I'm not using them interchangeably. A report, according to the federal rules, is when a university receives actual knowledge, meaning the Title IX coordinator or Safe Campus or an official required to report is aware of potential sexual misconduct, okay? And so, you know, on the screen, you can see a call to Safe Campus gives us actual knowledge, a disclosure to official required to report gives us actual knowledge, someone contacting my office directly gives us actual knowledge. That's considered a report, and that triggers our responsibility to offer supportive measures. A complaint is when someone requests that the university initiate an investigation. And this has to be received in writing from the complainant, or also the Title IX coordinator can submit that request. So in the past, we've used the word report to mean now what is being referred to as a complaint. So we apologize for that confusion, but we felt it would be clearer to our community if we came in alignment in this place, in this space, with those terminology, those terms, so that folks weren't confused when they were comparing the rules to what we're doing at UW. Okay. All right. I think at this point, I'm going to turn it over to Mags, and she's going to address the next section of content we have today. I'm starting with supportive measures, and then moving into investigation and adjudication of prohibited conduct. All right.
Thank you, Valerie. So like Valerie said, the regulations require that any time the university has actual knowledge an individual may have experienced sexual harassment or sexual misconduct, the individual will be offered supportive measures and receive an explanation of how to file a formal complaint. When the university has actual knowledge that someone may have experienced this, they have to be offered these supportive measures, and documentation needs to occur. This requirement pertains to any report of sexual harassment or sexual misconduct, regardless of whether the report meets the federal regulations definition of sexual harassment that I'll cover in a little bit. Documentation must include what supportive measures were offered, which supportive measures were pursued, and whether a requested supportive measure was not able to be implemented. If the university is unable to offer supportive measures to an individual, either because they don't respond to an outreach or otherwise, we also need to document why that is. In addition, we are required to document that the complainant was informed of how to file a formal complaint. And I will be referring to survivors or victims as complainants as I speak with you today, because that's the term that the federal regulations use. And they do not distinguish between somebody who has actually filed a formal complaint and somebody who has experienced harassment or violence and chosen not to file such a complaint. At the University of Washington, the Title IX protocol will remain in place. In implementing the regulations requirements around supportive measures, we did not want to change the messaging and training that we've had in place for years. Confidential advocates remain the individuals who can provide confidential support. And then Safe Campus and the Office of the Title IX Coordinator, which both maintain privacy rather than confidentiality, will continue to accept reports. When confidential advocates receive a referral from Safe Campus, the Office of the Title IX Coordinator, or an investigating office, advocates will track the supportive measures as required by the regulations. If someone directly seeks assistance from an advocate, those same record-keeping provisions do not apply because the university does not have actual knowledge. Thus far, I've talked about supportive measures as provided to complainants, and I will add that supportive measures may also be offered to respondents. So I will next speak about supportive measures in more detail. They are non-disciplinary, non-punitive, individualized services that may also be actions or adjustments and are offered free of charge to complainants and to respondents. Supportive measures are designed either to restore or provide equal access to a program or activity at the university, whether that is academic or employment related. The intent of a specific supportive measure may be to protect the safety of a party or others within the university community. Supportive measures may also be implemented to deter further sexual harassment. Examples of supportive measures include referrals to things like counseling or medical care, changes in housing location, helping people get out of a lease, or modifications in class and work schedules. No contact directives are another example of supportive measures. The federal regulations discuss no contact or directives as being mutual in nature. The university's practice of issuing one-way no contact directives will change, but this does not mean that one-way no contact directives will never be issued. Instead, investigators will conduct an assessment regarding whether a mutual no contact directive is not appropriate or appropriate for various reasons, and these will include safety. Further, the regulations contemplate that mutual no contact directives may be issued even when a complainant does not make a formal complaint, and even when an investigation is not opened. If a complainant is interested in a mutual no contact directive without making a formal complaint, confidential advocates and the Office of the Title IX Coordinator can discuss available options and what each would entail. I'll talk about formal complaints now. So Valerie had started to discuss the difference between, or had discussed the difference between how Title IX regulations define report and formal complaints. So the regulations define a formal complaint as a written document that is signed by a complainant or otherwise indicates it comes from a complainant. So an email would suffice. That does two things. First, a formal complaint has to allege sexual harassment. And secondly, a formal complaint requests that a university investigation occur. A formal complaint may only be made by a complainant or by the Title IX coordinator. The definition of a formal complaint is actually pretty broad, as the writing doesn't need to state any details about what happened, where it happened, or what specific definition of sexual harassment the complainant may be alleging. When a formal complaint is submitted, the university will assess the formal complaint, and then what happens next depends upon that initial assessment, which includes ascertaining whether the alleged conduct falls within the federal regulations definition of sexual harassment and meets the other criteria the federal regulations prescribe. If so, then the investigation and adjudication process will follow what is required by the federal regulations. If not, a dismissal of the formal complaint will occur for the purposes of the federal regulations. However, an investigation and adjudication process following what the university currently has in place may still occur. To ensure consistency in how the University of Washington evaluates formal complaints, all formal complaints and requests for investigations alleging sexual harassment will go to USERO or the Title IX Investigation Office. For all of you HR folks who are attending this session, if you learn of a complaint involving sexual harassment, please redirect the individual making that complaint to USERO and to a confidential advocate, both to ensure that the complainant understands their options about investigations and the process that a formal complaint may lead to, and also that that person has access to supportive measures. USERO and the Title IX Investigation Office investigators will determine whether the alleged conduct meets the definition of federally prescribed sexual harassment and whether the other criteria are met. Again, this assessment is needed to determine what procedures will apply to the investigation if one occurs. I'll cover this in more detail, but it is likely that when a formal complaint involves allegations of sexual harassment as defined by the federal regulations, the investigation will likely also include allegations of other UW policies that may have been violated. So I've talked about how the federal regulations define sexual harassment. So I'll actually talk about this in more detail and provide that definition. The federal regulations refer to all of the conduct that they cover as sexual harassment. At university, you will see in the policies that are forthcoming, Executive Order 70 and the Emergency Washington Administrative Code for the student conduct process. We'll be referring to this conduct as Department of Education Federal Regulations, and our acronym is EDFR, Sexual Harassment, or EDFR, Prohibited Conduct. What the regulations specifically prohibit is quid pro quo sexual harassment that occurs either by an employee toward another employee or an employee with requests or conduct directed at a student. The regulations do not cover quid pro quo sexual harassment by a student against a student. The federal regulations sexual harassment also includes hostile environment sexual harassment, which is defined as unwelcome conduct on the basis of sex that is so severe, pervasive, and objectively offensive that it effectively denies access to a complainant's academic or workplace environment. And the definition also includes sexual assault, dating violence, domestic violence, and stalking as defined by either the Clery Act or the Violence Against Women Act. University of Washington policy covers additional forms of sexual harassment and sexual violence. University policies include quid pro quo harassment that involves conduct or requests made by a student and directed to another student. Our definition of hostile environment sexual harassment is broader, as the unwelcome sexual conduct must be sufficiently severe, persistent, or pervasive. So it only has to be one of those things as opposed to all three. So that difference between the and in the federal regulations and the or in the university's policies is significant. And then UW policy also prohibits a broader range of sexual assault, sexual exploitation, and sexual violence. The federal regulations require that the University of Washington respond to the forms of sexual harassment that they prohibit, but the regulations do not limit to what other conduct UW chooses to prohibit, or as I'll discuss in the next slide, where alleged misconduct occurs. In addition to determining what process will be used when a formal complaint is made, which depends in part on what type of conduct is alleged, the investigator will need to determine whether the jurisdictional requirements needed for the federal regulations to apply are met. Again, the federal regulations require that we follow their prescriptive investigation and adjudication process when the alleged conduct occurred in the United States, when the alleged conduct occurred in connection with a university program or activity. As a note, this will be easy to assess if the alleged conduct occurred in a classroom or on-campus workplace. Alleged conduct will also be deemed to have occurred in connection with the university program or activity, likely when it occurs during an off-campus event sponsored by a registered student organization or staff organization, or during any type of conference, training, or other event to which the university sent its students or employees. For example, academic conferences in the United States would likely satisfy this criteria. In addition, the regulations apply to conduct that occurs on property owned by registered student organizations, which at the University of Washington will most likely translate to all sororities and fraternities. In addition, a complainant must be a student, employee, applicant, or someone who is participating or otherwise attempting to participate in university activities. So if a graduate, for example, remains active in an alumni association, it's possible that that graduate would also be considered a complainant, able to make a formal complaint as contemplated by these EDFR regulations. So if all of these criteria are met and the alleged conduct is EDFR prohibited sexual harassment, then the process prescribed by the federal regulations will apply. If an individual alleges conduct that does not meet either the EDFR sexual harassment criteria or does not satisfy one or more of these jurisdictional criteria, but nevertheless includes sexual misconduct that is prohibited by other university policies, such as Executive Order 31, 51, 54, or as defined in Part 2 of the Student Conduct Code, the investigation office will dismiss the formal complaint for the purposes of federal Title IX regulations and probably nevertheless conduct an investigation and adjudication process pursuant to other UW policies. For example, if misconduct is alleged to have occurred against a student by another student while both are studying abroad, the University of Washington might still investigate the allegations under the broader Student Conduct Code. Similarly, if the alleged sexual misconduct is against someone who is an employee at another university and who attended the same conference as the University of Washington employee, the university will still be able to investigate an investigation under its own policies rather than the federal regulations, as long as the alleged misconduct is covered by one of our policies. So this leads to covering different pathways through which an investigation may occur. So like I've said, we'll use the prescribed federal process when we're mandated to do so. This will be when the alleged conduct falls within the EDFR sexual harassment definition, happened in connection with a university program or activity in the United States, and is made by a complainant who is participating in or attempting to participate as a student, employee, or applicant to the University of Washington. Alternatively, we'll employ the processes we've used for years on the employee side and the process that has been in place since 2017 on the Student Conduct Code, on the student conduct side. Remember, University of Washington definitions are broader in that they prohibit more conduct, and the university is not restricted in terms of where conduct occurred or who was harmed by the conduct in order to address allegations. The respondent, of course, must still be a university student, the respondent has to still be a university student or employee in order to be subject to the University of Washington policies. So the federal regulations also require, in some places, that formal complaints be dismissed. And since we have to follow these federal regulations processes, dismissals will occur as required. So if after USERO and the Title IX Investigation Office receives a formal complaint, they will assess it and determine whether or not the federal regulations do apply. If a formal complaint does not fall either within the EDFR sexual harassment definitions or it does not meet one or more of the jurisdictional criteria, the formal complaint needs to be dismissed for the purposes of the federal regulations. If such a dismissal occurs, both the complainant and respondent will receive notification that the formal complaint or an allegation therein was dismissed, and both parties will have the right and opportunity to appeal the dismissal, which basically means that the party may assert that the federal regulations should apply. Any appeals of dismissals will be heard by different individuals depending upon whether the respondent is a student or employee. The university's review coordinator, Anton, will be reviewing appeals following dismissals where the respondent is a student, and investigators in the USERO and Title IX Investigation Office will be reviewing appeals following dismissals in cases involving employee respondents. And of course, the investigator who reviews an appeal of a dismissal will not be involved in the initial assessment or consulted with by the investigator who performed the initial assessment. So some walls will have to be created in that office for these complaints. So we thank both Anton and our investigators in UCR on Title IX Investigation Office for their willingness to assume this new responsibility. If a dismissal does occur and the federal regulations do not apply to the alleged conduct, the university may still investigate using parts 2 through 5 of the Student Conduct Code or other university policies that apply, for example, Executive Order 31. In addition to when dismissal must occur, there are also circumstances where dismissal may occur. These include when a complainant in writing asks to withdraw their formal complaint, when a respondent leaves the university, or when, for other unique reasons, the investigation is unable to continue. I'll note that House Bill 2327, which I mentioned earlier, requires that the university complete investigations. So it is unlikely that a respondent leaving the university will result in a dismissal. In terms of investigations, the federal regulations impose specific requirements, and many of these do not differ from UW's current practices. Investigators must provide notice of an investigation to the parties. This notice must include the name of the parties, information about where and when the alleged conduct occurred, and information about the facts of what's being alleged. In addition to these requirements, the notice will describe the non-retaliation policy and other required details. Anyone who would like to see a template of such a notice can contact me after August 14th. The investigation will proceed as University of Washington investigations always have, with investigators interviewing parties and witnesses and gathering potentially relevant documents. Investigators will analyze and assess the evidence that the investigation yields. Under the federal regulations, and this is a change from current UW practices, the parties will receive an opportunity to review the evidence that was gathered during the investigation. And the parties may share their perspective with the investigator about what they think is most relevant. After considering the parties' feedback, the investigator will complete a written report that summarizes the relevant evidence gathered during the investigation. For matters that do not include allegations of EDFR sexual harassment, the investigation process will not differ from how it currently occurs. When the federal regulations process is at play, a hearing with live, verbally conducted cross-examination also must occur. So I will talk about those live hearings. The federal regulations require that the hearing include cross-examination that is conducted by a party's advisor. The cross-examination must be live, direct, and conducted verbally. This is a difference from how cross-examination is conducted in student conduct hearings currently. The regulations require that cross-examination because the Department of Education believes that cross-examination is the best tool to determine the truth about what happened with respect to allegations. Parties are prohibited from conducting cross-examination themselves, and each party must be represented by an advisor who will ask cross-examination questions. Parties may select an advisor of their choosing who may or may not be an attorney. If a party does not select their own advisor, the university will appoint one for the hearing. During this interim time, student conduct officers at CSSC and those on the Bothell and Tacoma campuses have graciously agreed to serve as advisors for complainants and respondents in student conduct investigations that have to proceed pursuant to the federal regulations, and university complaint investigation resolution officers and Title IX investigation office investigators have agreed to serve as advisors for complainants and respondents involved in employee investigations. We are tremendously grateful for these folks' willingness to serve in this advisor role while we continue to evaluate this new rule under the federal regulations. And then just to be abundantly clear, none of these folks will serve as an advisor if they have otherwise been involved in investigating or consulting on a specific matter. Finally, the federal regulations prohibit the university from using any evidentiary codes, such as the Federal Rules of Evidence or the Washington Rules of Evidence. Evidence is admissible at a hearing if the decision maker or decision makers deem evidence to be relevant. In addition, the federal regulations included only a few other requirements regarding evidence. Evidence about a complainant's sexual history is very limited, and evidence regarding what would otherwise be considered privileged, such as medical or mental health records, may only be considered if the witness to whom the records belong provides written authorization for such records to be considered. Finally, if a witness does not subject themselves to cross-examination during a hearing, any information that they share during an investigation interview cannot be considered. And any statement in documents may not be considered unless the person who made the statement in a document agrees to testify at the hearing. So these are changes from the university's current practices, where student hearings only occur when or if a sanction of suspension or dismissal are possible, and employee hearings only occur for faculty and other academic personnel in limited circumstances. During the hearing, the university was given an option as to what evidentiary standard to use. So we were given the choice of what to use, so long as we decided to use the same standard in all cases that involve EDFR sexual harassment. The University of Washington will be continuing to use the preponderance of evidence standard, which it has used for both student and employee investigations for years. Preponderance of the evidence means, I'm sure you're all familiar with this, but that an individual may not be held responsible for allegations of misconduct unless the decision maker concludes, based on all of the evidence in the record, that it is more likely than not the respondent engaged in an act or acts of misconduct. This standard is also referred to as 50% plus a feather, and that is what is required in order to make a finding of responsibility. This standard is recognized as the best for cases involving individual civil rights because there is an equal burden in terms of both the complainant and respondent in a case. Though, of course, the burden is still on the university, but it gives 50% effectively to prove or disprove allegations. So since the regulations covering employees was a bit of a surprise to us, and this prescriptive process for investigating and adjudicating allegations of sexual harassment applies to all employees, and this is whether they're faculty, classified staff, academic personnel, professional staff, in addition to students. So this change is pretty significant for employees. So here are some of the primary differences between what the regulations require and what the university has typically done. It is a change that employees may review evidence gathered by an investigator before an investigative report is finalized. For employees too, the requirement of a written report summarizing evidence is a change. Previously, a written report was created only in limited circumstances. The requirement of a live hearing for every case involving EDFR sexual harassment is also a significant change, as a hearing only occurred in limited circumstances for faculty and academic personnel in the past, and then only as it was required by their own codes that those types of employees must follow. Decisions about whether or not an employee is found responsible for a policy violation, in this case, EDFR sexual harassment, will be made by either a hearing officer or a panel of decision makers. And the same decision maker or decision makers will decide the appropriate sanction if a violation of EDFR sexual harassment is found. So who makes this decision will depend upon what type of employee the respondent is, as the University of Washington must adhere to other codes in addition to the federal regulations. Finally, it's a change for employees to be able to appeal the university's decision. And complainants will now also have specific rights in investigations and adjudications involving faculty and other academic personnel. Typically, the codes governing these types of proceedings provided for rights for the individual accused of misconduct, but not for the complainant. And as a reminder, since the University of Washington will continue to have two pathways for investigation, when the federal regulations do apply, University of Washington policy will still apply in certain circumstances. This means that if EDFR sexual harassment is not implicated, investigators can still make decisions about whether university policies such as Executive Order 31 are violated, and then departments will continue to determine appropriate sanctions in those investigations. So now I will turn it back to Valerie so she can discuss phase 2.
Great. Okay. So you have just heard a very quick overview of our phase 1 implementation. And before we open it to questions, let me touch on what we expect to be addressing in phase 2, September and onward. First, we're going to take a couple of weeks to catch our breath. This has been quite an interesting and intense few months. But second, we'll develop a cohesive plan for moving forward. And I welcome suggestions on how to structure our planning. We know for certain it will include several elements. First of all, we need to assess what we've put in place for phase 1. For example, is the way that we're documenting supportive measures working? Or what better solutions might there be for providing advisors during EDFR hearings? Are we satisfied with the way we've defined and messaged our Title IX officials required to report? We need to evaluate those things and more. Second, we also need to address areas that we're not required to come into compliance, but that deserve our attention and careful consideration. Some of those topics include things like informal resolution. What processes or paradigms might we use to kind of ramp up the option of resolving these issues informally? Is there an appetite or resources for restorative justice, for example? Other topics we need to more fully flesh out include respondent supportive measures, procedures and practices related to patients in our medical centers, and a variety of other areas where we had some leeway in terms of how we address this. And then, of course, finally, our phase 2 work will include creating final policies and procedures. We're going into this with interim or emergency rules or policies. We'll need to finalize the WAC and consider more integrated ways to implement our executive orders and other related policies. So we have covered a lot in this last hour in a short time. Thank you for sticking with us if you have. And I do hope that you've made some note of questions that you have, and we'll stop the screen sharing here and take a minute to look at those questions and see if we can address those as well. I think we'll also stop recording at this time, again, just to make this particular session more manageable for folks to review if they join afterwards. So Mags, if you could